Hey friends, welcome to Stock Zurn Crypto Plays. I'm talking about AMC stock. Be sure to watch my previous two videos after this one. They're new, they've got fresh information you haven't heard yet, okay? So after this, watch those. There's two new ones. All right, here we go. Shout out to Ethan for posting the new letter from Judge Zurn, just released today. I don't even need to look it up. He's got it for us right here. Thank you, Ethan. Take a look here. I'm going to skip forward to the best part, okay? If you take a look, I love this part right at the end from Judge Zurn. She rips them like, okay, listen, just listen. Okay, let's see. Okay, second, the opinion is not final determination of whether the settlement should be approved. The opinion pointed out the release was unsound and could not be approved and encouraged the defendants to weigh the risk from a narrower release. In so many words, the opinion gave the parties an opportunity to narrow the release. Following a nuance of class action practice before this court, and as it contemplated by the plaintiff's counsel at oral argument, if the parties did not choose that path, the opinion directed the parties to submit a consolidated complaint, a task they should have accomplished weeks ago. That is embarrassing for Adam Aaron and his lawyers. The judge just ripped them in an open letter, published openly to the public. A task they should have completed weeks ago. But here we go. This request did not lift the stay imposed by the May 1 scheduling order. The stay remains in place. She said that in such a powerful way. You can tell a lot about the way people speak, and when they write, you can hear them speaking. She said that in such a powerful way, and then she reiterated it after she said it. She said it again. Okay, so the stay, what does that mean? That means they can't do a reverse split. They can't do an APE to AMC implementation. Okay, it needs to be approved by her. She's not approving it. She's keeping the stay in place. It says here, this request did not lift the stay imposed by the May 1 scheduling order. Strong statement. Then she doubles down and she says, the stay remains in place, period. Boom. All right. So this is the new letter, basically page 1 right here. It says, Dear Counsel, I'm writing in response to two recent filings, the parties' July 22nd letter and Rose Izzo's motion for clarification or alternatively for maintaining of status quo order pending appeal, the motion. The letter enclosed an addendum to the April 7, 2023 stipulation, and the letter enclosed an addendum, settlement and release, and a revised proposed order and final judgment. The addendum revises paragraph A1R, the release of the parties' settlement stipulation as reflected below. Released plaintiff's claims means any and all action, causes of action, suits, liabilities, claims, rights, action, debts, blah, 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 blah. It's a lot of legal jargon there. Shall or may have directly represented, more legal jargon, just too much legal jargon. The revised proposed order reflects the addendum. In the letter, the parties request 1, that the court approve the settlement on the revised terms and pursuant to the enclosed proposed final judgment, and 2, that the court stay its order directing the plaintiff to submit a consolidated complaint and the parties to submit a schedule for the remainder of the litigation. The parties argue additional notice need not be provided prior to settlement approval because the changes to the proposed settlement do not adversely affect the class. The motion seeks clarification as to the effect of my July 21st opinion. The parties argue, the motion seeks clarification on the stay of all proceedings against the defendants imposed by the May 1 scheduling order and on February 27, 2023 status quo order. I have plucked the low-hanging fruit from the letter and the motion and offer what guidance I can. First, the parties need not renotice the proposed settlement. The release as trimmed by the letter is narrower than the version included in the notice of stockholders. The parties exercised the clause releasing APE claims because the court rejected that clause as legally impermissible. Removing a clause that has no legal effect does not adversely affect the putative class. Still, I have ordered in this case to date, July 22 letter, all of it its enclosures, and the letter should be posted on the websites for AMC Entertainment Holdings, Inc. and the Plaintiffs' Counsel no later than 8 p.m. Eastern today, June 24th. So they still have a little time to post it on the AMC website for investors. Second, the opinion is not final determination of whether the settlement should be approved. The opinion... Okay, we read this part. That's it. It's just a short letter. So you got the rundown, friends, okay? Hit like, subscribe, and notifications. Share the video with a friend. Thank you to Ethan for posting that. AMC stock is trending. What do you think about all this, guys? AMC breaks new weekend high record in 4 years. That is true. Barbie and Oppenheimer are blowing it out of the water. They're making tons of money, okay? Did you see my tweet here? Hit like if you think Adam Aron was furiously angry that AMC stock went up so strongly today. And I posted that when Friday after hours. Take a look. Friday after hours, $8.15 at 3:20 p.m. And then do you think Adam Aron was furiously angry that it went up so high? Of course he was. Look, we got 339 likes on that thing, guys. Okay? Of course he was angry AMC stock went up. That's why he did the letter Sunday night to crash the stock today, Monday. All right? Talk to you soon. Have a great day.